Hello everyone and welcome to the May 2026 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy, and also Executive Partner Robert Carr. My colleague and partner Mr. Carr will be broadcasting with me today, which we are very excited about. Today's topics first include our usual most recent case law update. The first case law update is on the unpublished opinion per curiam of the Court of Appeals issued on April 20th, 2026 called Jawad a Shah PC, Alliance Anesthesia PLLC, Insight Anesthesia PLLC, and Insight Radiologists PC versus Auto Club Insurance Association. The second case we will discuss is another unpublished decision per curiam of the Court of Appeals that was issued on April 23rd, 2026 called MemberSelect Insurance Company versus Michael James Clancy, personal representative of the estate of Connor James Clancy, and Anthony Dwayne Magee and Debbie Magee. Lastly, Mr. Carr will focus our discussion on the trending topic of PIP litigation pertaining to a recent lawsuit by both Uber and their insurer, Liberty Mutual, directly against a New York fraud ring, attorney firms and medical providers accused of staging multiple hit-and-run accidents and funneling ring members through fraudulent, unnecessary treatment. The first case we will discuss is the unpublished opinion per curiam of the Court of Appeals issued on April 20th, 2026 called Jawad a Shah PC, Alliance Anesthesia PLLC, Insight Anesthesia PLLC, and Insight Radiologists PC versus Auto Club Insurance Association. This case addresses a significant issue involving the calculation of PIP benefits under Michigan's amended No-Fault Act, specifically whether insurers may apply Medicare's multiple procedure payment reduction, or MPPR methodology, when determining reimbursement rates for medical providers under MCL 500.3157. Defendant Auto Club insured a non-party individual under a no-fault policy. In 2021, its insured sustained injuries in a motor vehicle accident and later underwent medical treatment, including MRI services provided by all of the plaintiff medical providers. When reimbursing the providers, Auto Club applied Medicare's MPPR rule. Under Medicare, when multiple imaging procedures are performed during the same patient encounter, reimbursement for secondary procedures is reduced by a specific percentage. Plaintiffs contend that the insurer improperly reduced payment and argue that the no-fault statute required reimbursement without application of MPPR reductions. The dispute, therefore, centered entirely on statutory interpretation of the Medicare-based fee schedule provisions enacted as part of Michigan's no-fault reform legislation. Plaintiff medical providers sued Auto Club in district court, seeking additional reimbursement for the MRI services at issue. Auto Club moved for partial summary disposition, arguing that it properly applied the Medicare MPPR reduction when calculating benefits under MCL 500.3157 subsection 2. The district court denied the motion with prejudice. Auto Club sought leave to appeal to the Wayne County Circuit Court, which granted leave but ultimately affirmed the district court's ruling. The circuit court held that MPPR reductions constituted limitations unrelated to Medicare fee schedule rates and therefore cannot be considered in calculating PIP reimbursements. The circuit court had relied on the case of Central Home Healthcare Services versus Progressive to conclude that MPPR reductions occurred after application of the fee schedule and therefore were unrelated to the fee schedule rates themselves. Auto Club then filed an interlocutory appeal with the Michigan Court of Appeals. The key interpretive issue there was whether MPPR reductions are, quote, related to, unquote, Medicare fee schedule rates or are instead excluded limitations unrelated to those rates. The Court of Appeals framed the dispositive issues as whether MPPR constitutes a limitation unrelated to the rates in the fee schedules under MCL 500.3157 subsection 15F. Applying the case of Favat versus Brown, the court held that MPPR rules are related to Medicare fee schedule because they directly affect the amount payable for services under Medicare. Accordingly, insurers are permitted to incorporate MPPR reductions when calculating no-fault reimbursements. The court emphasized that Favat was binding precedent and therefore controlled the outcome, even though the lower courts lacked the benefit of that decision when ruling. The court therefore reversed the circuit court's affirmance of the district court's denial of summary disposition and remanded for further proceedings. Judge Rick concurred in the result, but wrote separately to criticize FABUT. Namely, he believed that the legislature intended Medicare fee schedules merely as pricing benchmarks and did not intend downstream reimbursement methodologies, such as MPPR reductions, to apply. According to the concurrence, MPPR rules operate only after the baseline fee schedule amount is determined, and therefore should not reduce PIP reimbursements. Nevertheless, Judge Rick agreed that FABUT was controlling authority and therefore concurred in the judgment. This ruling is important because it confirms that insurers may apply Medicare payment reduction methodologies, including MPPR adjustments, when calculating allowable reimbursements under Michigan's No-Fault Act. This decision favors insurers and narrows the reimbursement amounts recoverable by medical providers. The case also reinforces the growing body of appellate authority interpreting the 2019 no-fault reforms in favor of incorporating broader Medicare reimbursement methodologies into Michigan PIP calculations. Finally, the opinion highlights continuing judicial disagreement regarding interpretation of MCL 500.3157, particularly whether the legislator intended to adopt only Medicare fee schedule rates or also Medicare's various payment reduction rules. Because FABUT is reportedly pending before the Michigan Supreme Court, the issue may ultimately receive further clarification from the state's highest court. The second case we will discuss is the unpublished decision per curiam of the Court of Appeals that was issued on April 23, 2026, called MemberSelect Insurance Company versus Michael James Clancy, personal representative of the estate of Connor James Clancy, and Anthony Dwayne Magee and Debbie Magee. This case concerns the balance between an insurer's common law right to rescind an insurance policy procured through fraud and the equitable protections afforded to innocent third parties injured by the insured's conduct. Specifically, the court examined whether an insurer may rescind a policy after the fatal motor vehicle accident when the insurer arguably could have uncovered the insured's fraud through minimal investigation before the accident occurred. Defendant Anthony Magee, while driving intoxicated and with a suspended driver's license, collided with Connor James Clancy, killing him. Prior to the accident, Anthony had moved into defendant Debbie Magee's residence and asked Debbie to add his truck to her automobile insurance policy with MemberSelect. Notably, the Court of Appeals did not note precise familial or marital relationship between the Magees. When Debbie contacted MemberSelect, she represented that she was the truck's primary driver. She failed to disclose that Anthony actually owned the truck and that Anthony lived in her household. Based on these representations, MemberSelect added the truck to Debbie's policy. After the fatal accident and ensuing wrongful death litigation, MemberSelect investigated and rescinded the policy, asserting that Debbie's misrepresentations constituted fraud in the procurement of the insurance coverage. The parties did not dispute that Debbie committed fraud. Instead, the dispute centered on whether rescission should nevertheless be denied on equitable grounds because the decedent's estate constituted an innocent third party. MemberSelect filed a declaratory action in Wayne County Circuit Court seeking rescission of an automobile insurance policy issued to Debbie Magee. Following the fatal collision involving Anthony Magee and Connor James Clancy, the decedent's estate also pursued a wrongful death claim against Anthony Magee. Anthony and Debbie sought indemnification from MemberSelect, prompting the insurer to investigate the policy application. MemberSelect alleged that Debbie made material misrepresentations when adding Anthony's truck to her policy and sought summary disposition under MCR 2.116C10. The trial court granted summary disposition in favor of the insurer, concluding that rescission was equitable after weighing the factors identified in Justice Markman's concurrence in Farm Bureau General Insurance Company of Michigan versus Ace American Insurance Company. Defendant Michael James Clancy, as personal representative of the estate of Connor James Clancy, appealed as of right. The Court of Appeals reiterated long-standing Michigan law that automobile insurance policies are governed by both statutory provisions and common law contract principles, and insurers retain common law fraud defenses unless expressly prohibited by statute. The opinion explained that rescission abrogates a contract and restores the parties to positions they would have occupied if the contract had never been made, and remains an equitable remedy subject to judicial discretion. The court relied heavily on several Michigan Supreme Court and Court of Appeals decisions addressing insurance rescission and equitable balancing. The court focused on the 5 non-exclusive factors in the case of Farm Bureau General Insurance Company of Michigan versus Ace American Insurance Company identified in Justice Markman's concurrence. And those are: 1, whether the insurer could have uncovered the fraud before the injury; 2, the relationship between the insured and the innocent third party; 3, the innocent third party's conduct; 4, availability of alternate recovery sources; and 5, whether enforcing the policy merely relieves the fraudulent insured of liability. The court primarily focused on the first of the Farm Bureau factors, whether the insurer could have uncovered the fraud before the accident through reasonable diligence. The trial court had concluded that this factor favored rescission. The Court of Appeals disagreed and found clear error. The court noted MemberSelect never asked Debbie whether she owned the truck. A simple title search would have revealed Anthony as the actual owner, and discovery of the ownership discrepancy would have prompted additional investigation before the accident occurred. The court concluded that the fraud could have been uncovered through minimal due diligence, meaning the insurer's own lack of investigation enabled the fraud to persist. Because the first factor from the Farm Bureau case weighed against rescission, the balance of equities shifted in favor of the innocent third-party estate rather than the insurer. The court held that the trial court clearly erred in determining otherwise and reversed the grant of summary disposition. This decision significantly reinforces protections for innocent third-party claimants in Michigan insurance rescission cases. This case confirms that fraud alone does not automatically justify rescission. Insurers must demonstrate equitable entitlement to rescission, and courts will closely scrutinize whether insurers exercise reasonable underwriting diligence. Practically, the ruling may encourage insurers to implement more underwriting and verification procedures, because failure to conduct basic investigation may later bar rescission against innocent claimants. For plaintiffs and wrongful death claimants, the decision strengthens arguments that insurers should bear the consequences of inadequate underwriting, where innocent third parties otherwise would be left without compensation. And lastly, the opinion also continues Michigan courts following the Magee versus Sentinel Insurance Company trend of limiting rescission in circumstances where equitable considerations favor innocent accident victims over insurers seeking to void coverage retroactively.
We want to now focus our discussion on the trending topic of PIP litigation pertaining to staged accident fraud recovery. The case is Uber Technologies Incorporated et al. Versus Powell et al. 226 CV 02195. U.S. District Court for the Eastern District of New York, filed April 14, 2026. The case is a partnership of Uber, its subsidiary Razor, its an insurer, and its insurer, Liberty Mutual, going not only directly after a crime ring of connected people who stage Uber accidents in New York, but also after the attorneys and medical providers who then provided fraudulent, unnecessary treatment. The central issues are counts 1 through 3, common law fraud, unjust enrichment, and civil conspiracy against a group of Uber passengers, friends, and relatives who actively carried out a scheme to book Uber rides and have a friend and or relative intentionally cause an accident with the unsuspecting Uber drivers. Count 4, declaratory judgment under 28 U.S.C. Section 2201 against the fraudulent care providers and the 2 plaintiff attorney firms that the accidents were not the product of covered events as defined by the applicable policy of insurance issued by Liberty, which is Uber's counsel for Razor policies in New York, as they were the product of caused and or staged and or intentional events, and therefore Liberty has no obligation of coverage. The defendants include AccuCare Solutions Incorporated, Advanced Ortho DME Corporation, Liberty MD LLC, Medical Supply of New York Direct Services Corp., Ortho Med Spa Incorporated, Rockway Boulevard Pharmacy, Simeon Isaacs, MD, and Super Associates, PC. The last two, at least the last one, is the attorney on the case. And also count 5, declaratory judgment due to defendants not participating in examinations under oath, which is a New York law. As alleged by this lawsuit, a group of 14 people, which the complaint calls the fraud ring, their friends and relatives, carried out 8 staged accidents from August 13, 2023 to March 1, 2025. Group members would pick locations that did not have cameras to lure drivers for Uber pickups. The pickups were at night to avoid witnesses. Shortly after picking up a few of the fraud ring members, the Uber driver would then be hit by another member of the fraud ring with minimal impact, and that other driver would then flee the scene. The fraud ring members in the Uber would allege serious bodily injuries, even though the drivers are usually uninjured. The fraud ring members, using 2 named attorney firms, then submitted fraudulent claims of fabricated and blatantly misrepresented personal injuries to Uber and overtreated for the fictitious injuries with 6 medical providers, including a pharmacy and DME suppliers. Liberty SIU representatives, assisted by Uber, were able to piece together the scheme as examinations uncovered how the various fraud ring members were related to each other or were using the same addresses and even the same cell phone number. In New York, medical providers can arbitrate their bills with the insurers within the American Arbitration Association. During the arbitrations, Liberty attorneys were able to convince arbiters that the accidents were staged losses, and these arbiters issued written recommendations pointing out this fraud. New York State leadership, led by Governor Hochul, came out strong earlier this year against insurance fraud, and in particular against staged accidents, which were deemed a pervasive drain on the national healthcare system, according to a March 15, 2026 report of the New York State Department of Financial Services. New York is the second in the nation for staged crashes. Florida is currently number 1. New York isn't the only city Uber is fighting fraudulent personal injury claims in courts. Uber and FedEx are engaged in RICO lawsuits in Philadelphia, Los Angeles, and Miami, amongst other cities, against law firms and medical providers accused of directing clients to chiropractors, pain specialists, and other medical professionals, who in turn create fraudulent medical records for the client. In Michigan, more than 1 out of every 10 no-fault cases is believed to be fraudulent, costing drivers $20 billion annually in higher premiums and pushing the state to number 1 in highest auto insurance premiums at more than $5,000 per year in average cost. Officials in Michigan and New Jersey are seeing an increase in staged accident claims. Fraud rings had been focusing on the trucking industry previously, but rideshare setups where the accidents are more likely to be safer sideswipes seem to be taking over. In February 2026, Michigan expanded its auto insurance fraud unit into a broader auto fraud task force. For drivers, experts recommend installing dash cameras and vigilance in driving to deserted areas. Testimony of those who admit participation in the rings say they avoided rideshare vehicles with cameras. For the insurers, experts point to extensive examinations under oaths and depositions with the driver and all passengers in each hit-and-run rideshare accident. Fraud ring members typically participate in multiple fraudulent crashes, usually carried out the same way. Database searches of common addresses and phone numbers used by the fraud ring passengers eventually provide links to multiple suspicious crashes.
That concludes the May 2026 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to Caitlin Milroy, Robert Carr, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topics in the PIP world. Take care, everyone.